Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Over the course of the past several months, I have produced content dealing with Mr. Kohberger's alibi defense, which he raised willingly in 2020. ICR, Idaho Criminal Rule 12.1 says that if a defendant wishes to raise an alibi defense, he must comply with the statute, which is 19519 of the Idaho statutes. This is the law of the state of Idaho. This law says basically that if you are, as a defendant, going to try to raise reasonable doubt, say that you could not have been the perpetrator here because you were elsewhere, you have to do two things. When the prosecutor serves discovery, the clock's starting to tick right now. You have 10 days to do the two following things, which the state of Idaho did back on May 23rd, 2023. You have to say with specificity where you were at the time that the state of Idaho alleges you were at the crime scene, which is the crucial time of 4 a.m. through 4:25 a.m. on November 13th, 2022. There's been a lot of speculation, argument, thought that these crimes happened at a different time, but all of that is irrelevant in terms of the alibi defense. He needed to state specific facts of where he was, not generally, but specific facts. And two, cite the names or name of a witness or witnesses who could vouch for you. It asks him to state specifically, meaning at 4 a.m., I was here. At 4:25, I was here. And where he was in between those 2 points. Simple. Done. And also, witness who could vouch for him. There's two types of witnesses in a case. You have fact witnesses and you have expert witnesses. A fact witness has direct observation, is testifying on something of relevance based on their personal knowledge. They testify about what they saw, what they heard, what they experienced, what they know personally. In other words, it might be someone who, if Mr. Kohberger stopped somewhere on the night in question, pulled into a gas station, purchased some gasoline, the person who waited on him would be a fact witness. That would be someone with direct knowledge because he personally interacted with Mr. Kohberger during that crucial time frame. He has not produced the name of a single person as a fact witness. What he's done since 2023, when he first responded to the notice of alibi, months after it was served upon him, was that a proposed expert witness, Cy Ray, would be able to give his opinion based on technology that he was not at 1122 King Road between 4 and 4:25. Now, if Mr. Ray comes back and files this affidavit or declaration the judge instructed defense to have him do on the 18th of March for this hearing on this in limine motion, which is coming up in less than a week, beginning on the 9th of April, and produces information that Mr. Kohberger was at X location per his opinion at 3 a.m., that's irrelevant. It's where was he between 4 and 4:25. And if Mr. Ray is not able to do that, why this was even raised as an alibi defense. An expert witness is not testifying on personal knowledge like a fact witness does. An expert witness is giving an opinion. That's what an expert does, based on specialized knowledge, skills, and experience. Hippler may turn around very well and say, the law is clear. You have 10 days to produce where you were with specificity and who could vouch for you. And an expert witness cannot personally vouch for you. They give opinions. That's all they do. And guess what? The defense has never produced a scintilla of legal authority, a case that says that Judge Hippler is allowed to change the language of the statute, which appears to be very clear. And there's been some discussion, he was waiting to get discovery back from the state. If the statute intended a defendant to go to the state to help him create his alibi defense of explaining where he was at 4 o'clock to 4:25, the statute, I think, would have a much larger window than 10 days. And why does he have to go to the state to provide the information that he should know? He should know exactly where he was at 4 to 4:25 a.m. Not sure why the state needs to give him information so that he can explain where he was. And one final thought, as I continue to give my opinion based on the facts, is that a lot of people have had some dispute with this statute. It's unfair. He shouldn't have to give up his Fifth Amendment privilege of not speaking. Well, you know what? When you raise an alibi defense, you willingly do it. That's why the statute says if, not when. And secondly, if the people of Idaho felt that this statute was inappropriate or should be changed, it's up to them to go to their legislatures and to convince the legislatures to change this law and for the legislators to do so. Until then, it's the law of the state, whether we like it or not. He never had to raise an alibi defense. I think it's an aha moment that after 2 years, or should be, that he still has not explained where he was every minute of that time frame, from 4 o'clock to 4:25. Not generally, not saying I like to go for drives because I like to look at the stars. I've done this for years. But where was he from November 13th at 4 o'clock to 4:25, period, end of discussion? I think that this is a real turning point in this case if he continues to evade what Judge Hippler said 2 weeks ago, that RE is to produce a declaration. He's produced 2 other declarations, but not for the alibi defense. And if he decides to produce one today, tomorrow, next week before the hearing, and it doesn't say where Mr. Kohberger was between 4 o'clock and 4:25 a.m. on the 13th, based on Mr. Ray's opinion, that should be an even larger aha moment.